the main focus of this webinar is on different aspects of intellectual property rights such as patent, design, trademark, and copyrights and geographical indication. It will help, I think, definitely all the participants will learn many things and enjoy this webinar, and this will help in shaping the environment conducive to innovate the creativity by bringing the transformation in participant skill of UG and PG project, and this will definitely boost the research work to make them more result oriented. So let me introduce Mr. Salendra Singh sir. He is graduated from SRM University in 2014, SRM University Chennai. Is BTech Mechanical Engineer, and then from 2016 onward, he joined Patent Office. The Government of India is a gazetted Group A gazetted officer, and he will deliver his special lecture today. So now I am requesting our Dean Academic Affairs, sir, Dr. G.S. Lamba sir, to say a few words about this today's special lecture. Over to Lamba sir.
Thank you, Dr. Banerjee. It is my proud privilege from Akal University to welcome all the participants on this very important topic of the intellectual property rights. And special thanks to Mr. Shailendra Singh to have accepted our invitation to give details of this topic to our faculty members, students, and number of other participants from other universities and colleges. Intellectual property right is a very important topic from the point of view of taking the benefit of the one's innovative efforts, getting it recognized so that any academic as well as financial advantage is to the person who is the right person for having developed that particular concept or technology or product. Depending upon the kind of product, whether it is a concept, whether it is a theorem, whether it is a product or any improvement in the product, there are different type of IPR issues, whether it is for trademarking, whether it is for copyright, or it is for granting patents or continuing patents. For any innovator, it is important to know all the steps and follow the rules which are there at the national level as well as at the international level. Various countries have certain specific variations in the Copyright Act. I'm sure the audience are going to get full advantage of Mr. Shailendra Singh's experience and wisdom, which is going to flow over next hour plus during this today's webinar. Once again, I welcome all the audience and congratulate the organizers from the Akal University and Dr. Bhuban Banerjee for this particular event. The Akal University always endeavors to bring such topics into the forefront and organize the expert lectures on such topics. Without taking too much of time, I would hand over back the podium to Dr. Bhuban. All the very best and have very scintillating interaction with Dr. Shailendra Singh. Thank you.
Thank you so much, Lamba sir. Now I am requesting Shailendra Singh sir, without wasting any further time, please start your today's special presentation, and now you can unmute yourself and start your presentation. Thank you so much, sir, once again.
Thank you, Banerjee ji, and very good morning to all the dignitaries, Dean sir, and all the faculty members of the Akali University. And it's my honor that Akali University has given me the opportunity to share my learnings from Patent Office New Delhi with all of you. Today's we are going to learn about intellectual property rights and what is intellectual property right, what are the rights we can ask for from the government, and what are the different things we can register in this intellectual property right, why it is important for us. Everything we are going to touch in this today's lecture. And first of all, we need to understand why we are having this webinar. uh, Whenever a country grows, like whenever a country like whenever a developing country grows, whenever any country start doing more and more development, most of the people, more people start investing in the business thing. More people start their work as a business person. We see now many people have their own startup, and there are so many creative things that are coming into this world. So for any business, for any startup, for any company, it is very much important to understand their own creativity, to understand and to have the exclusive control over their own creativity. Like we see that in any developed country, like in US, UK, or any other country, we see that the IPR laws are very much strong in those countries. The reason is that the most of the people in those countries are the business people who are working, who are running their own businesses, and they want their business to have they want to have their exclusive control over this their own business. So for any country like India, for any developing nation, it is very much important to understand our own creativity, to have a better understanding of our own rights, and these rights are intellectual property rights. Now, all we have already known about the many tangible rights. Tangible right means whatever things that we can see, like the land, the cars, buildings, these are all tangible rights. Now, there is another property which we usually don't give so much importance, and this property is intellectual property right. And what is the intellectual property right? Intellectual property right is an intangible right, means the something which we cannot see. It is a saying that IP is like a glue in something. Now, until and unless the things fall apart, till then we don't understand the importance of this glue. So IP is a glue in that thing. So without wasting much time, I should first move to our my presentation. And before starting the presentation, I would like to show you something, a small video clip, just to acknowledge you all that whatever we are seeing around us, whatever is there around us, whatever, like the chair, table, this laptop, everything, the clothes, everything is a part of IPR. And we never gave the importance to all these creative people who have created this. We never give the importance to them, to the proprietor of these things. Proprietor means the person who is the actual, the real creator of these things. So I would like to show a small video clip before starting a presentation, just to acknowledge you all that everything around us is a part of IP. So can you see now in my screen video clip? Can you see the video clip?
Yes, yes,
Okay.
yes, sir, yes,
Yes.
sir.
Yes. Now just look at the different places in the video that something is written, like here it is written that geographical indication. Now this painting is a part of geographical indication rights. Now in different parts of the video, you will see the different these words in different parts of the video. Even the things that we eat, there are many things that we usually consume are a part of geographical indication, like this rasgulla or mangoes or oranges. These are all part of the GI, geographical indications. Now, even a single product can have multiple IPs linked with it. Like when we use this mobile phone, this mobile phone has these different IPs linked with it: patent, trademark, copyright, design. So a single product can have multiple IPs linked with it. So I think this must be a little bit clear to you all that everything around us is a part of IPR, and we should always try to protect our IPs. So we should move to our presentation thing now. Is my presentation slides visible to all?
Yes, sir.
Okay. So we are having this webinar under the IPR awareness mission, and this is NEPAM, organized by Ministry of Commerce and Industry. So first of all, we need to understand that what is IPR? IP. IP is intellectual property. It is the creation of mind. Whatever we create out of our intellectuality, out of our brain, is a part of intellectual property right, जिसको हम हिंदी में बोलते हैं इंटेलेक्चुअल प्रॉपर्टी को बौद्धिक संपदा, अपने बुद्धि की जो संपदा है, जो प्रॉपर्टी है, is a intellectual property rights. There are multiple different divisions in intellectual property, and these divisions are patent, design, trademark, geographical indication, copyright, and the semiconductor integrated circuit layout designs. So these are the different divisions in intellectual property. Now here everyone would be seeing a laptop. Now we can easily recognize this laptop. That is a Apple laptop. Now what are the ways in which we can recognize this thing? The first thing is the logo. Logo itself tells us that this is an Apple laptop. Now what are the different IPs that would be linked to this Apple laptop? The design, the outer surface of this laptop, the 2D 3D structure that we are seeing is a design registered thing. Now all the technologies that is used in this laptop is a patent registered thing. This logo is a trademark registered thing. Now all the user manuals, the programming algorithm that is used to run this program, this laptop, is a copyright registered thing. And the this electronic circuit used in this laptop is a SICL design registered thing. So there are multiple this IPs linked with a single product, and we can register our creativity in multiple IPs. So what is the importance and significance of this IPR? protection, the thing for this is the importance is it will protect you, it will exclude others from making it or manufacturing it, and it will help you to commercialize and earn from those things. Now there are two different people who would like to register their IPs, and these two different people are common people or a businessman. Now for the common people who don't
Excuse
want
me,
to,
sir.
yes,
Excuse me, sir. Salindra sir, your slide is not moving.
okay, now is it moving?
No, sir.
Wait, let me,
It is fixed on the first page.
okay, let me reopen. Now is it visible?
Yes, sir.
Okay, now is it moving?
Yeah, yeah. Now it is okay.
Okay, so now here we are. So there are two different type of people who will register for this IPR thing. Now the common people and the businessman. Now for the businessman, it's easily known that they will be registering these IPs for the commercialization or brand value or to earn something. And for a common person, like for a researcher or for a professor or for a any academician, it will be a thing for a pride or addition to their own CV. So there are two different people who will register for these IPs. All we have seen a movie, Three Idiots. Now in Three Idiots, there is one character, Amir Khan's character, who was a scientist. Now he in real life, he is a scientist in Leh, and he has already registered more than 400 patents with the government. So he don't use these patents for the commercialization, but this is a thing for pride for them, for him. So for a common person, if you want to register, it's not necessary. If you want this IPR, if you want to register patents, or if you want to do this registration for, it's not necessary you do the business out of it or you do commercialization. It may be a thing right for you. Now we should move first for our first IPR thing, that is patent. Now what is basically a patent, and for how many years it will be protected, and what are the different laws. So what is patent? Patent is basically a sovereign right or a straight right given to a person. What does it mean? It means if you are filing for a patent in India, then it will remain protected only in India. You cannot ask for this exclusive right if you have not filed for that thing in that country. Means if you want to protect your technology in US, UK, India, China, in these four countries, then you have to first file patent in all those four countries: US, China, India, and UK. After this, your technology will be protected in all those four countries, all these four countries. And if you have not, if you think that I have already taken the patent in US and now I am having the exclusive right in India as well, no, it's not the case. If you only get the protection in India when you have registered that thing in India itself. So patent is a sovereign right, first of all. Now the second thing, it is for a limited period. Limited period means you will get the patent for a year of 20 years. Means if you have registered from today's date, that then from today's date Up till next 20 years, it will be protected and it will become exclusively your property. Now, what is actually a patent? Patent is basically any upgradation to the known technology or any new technology that you have given, or any new device that you have given, or any process that you have given. Something like, you can say in simple words, that if you are creating something to solve any problem. Now, I would like to show a small example. Now we having this pen. Now let us assume that we all have this pen without this cap. Now everybody is having this pen without the cap. And if what are the problems linked with this pen now? Now, if I keep this pen on the table, now what will happen? This pen will roll and may fall down on the ground. And if I keep this pen in my pocket, it will not remain stuck at a particular position, or may the ink may get leaked. So these are the many problems linked with this simple pen. Now one day an idea came to my mind that there should be something to cover this up, cover this pen thing, and I have created this thing, this cap. Now this cap become a new product which is novel in itself and which can be patented. Now we can say that it can be a patented technology. So this cap becomes a new innovation in this pen industry, in this writing industry. It becomes a novel innovation. So anything, any simplest thing, anything can be a new innovation. Like you may not be knowing that a safety pin that we usually use to tuck our clothes, the safety pin is also a patented technology. The simpler things, there are many simpler things that we all know. These are all new innovations, new. And basically, what is actually an innovation? It's a something called problem solution to any problem. Earlier, we used to face any other problem, like we see a stapler. The used to club pin together the papers. This stapler. Now stapler becomes an innovation. Earlier, what we used to do, we used to use a small alpin type thing to join to clip all those paper. After that, a new innovation came to existence, and we came to know about the stapler. Now this stapler has become a new innovation, and this type of things can be patented. Now we can see the few past invention, this phonograph, telephone, aeroplane, rabies, and penicillin. So there are so many past invention and so many past scientists we already know. First of all, we need to understand a few things, that for in the present time, most of the fundamentals have already been told to us. All the fundamental studies, all the fundamental technologies or laws are already been into our acknowledgement. But what we can do, we can upgrade the past things, past known technology. Like earlier, we used to have the telephone, the wired telephone. After that wired telephone, we came to know about the cordless phone. After that, the cellular phone, mobile phone came into the picture. Those small phones. After that, touch screen phone, then single SIM phone, then dual SIM phones. Now the foldable phone. So these are the upgradation in the past technologies. So it's not necessary that if you are having some technology, there is no scope of upgradation in that. No, it's not the case. You can upgrade the old technology, and this is actually what is going on in the present scenario. Whatever we are doing, we are just upgrading the past technology. We are upgrading the new thing. We now recently we came to know in the last 4 or 5 years about IoT. Internet of Things. Now in IoT, we have all the electronic products in our house, or yeah, many products we have in our house that can be connected with the internet, and we can utilize for our own purpose. Like we can switch on the AC from our office or from our car. So these are the things which are linked with the IoT. Now this IoT is an innovation in itself. Now this technology can be patented. So any upgradation in the past prior arts is a thing of patent. It's an innovation. There is a very beautiful way of writing a patent application in Japan. In Japan, what they usually do while drafting the application in the abstract thing, what they do, they write their application in the manner. Then the application itself defines everything. Now, what they do, what is the problem in that past technology in the prior art? What is the problem? And in the second thing, they write the solution. This is the solution of the problem. So basically patent or any innovation is a solution to any past problem. Now here you can see a very simple innovation, the simple innovative cap. Now this cap, what it's doing, now this cap is protecting this infant's face from getting wet. Now no, any innovator, anyone who thinks in this innovative way would understand that it's a very simple thing. We all know about cap and everything, but we have not thought about this product earlier. We have never thought about it. We have never think in that way ki, there can be something which can be helpful to these infants. So any simpler technology, anything, it can be anything. It can be any device, any technology, any process that can be problem solving to us, and this solution, this innovation can be patented. Now these are just simple news articles from different organization. Now Apple, Toyota, Defense Ministry. So I've just clipped these articles just to acknowledge you all that all the technologies that are being created, that are being developed by any industry, any company like Apple, Toyota, Maruti, XYZ, any company or any pharmaceutical company, these technologies are first patented so that they could protect their innovation, their technology from others, so that they should, before launching their device or their technology in the public domain, before before bringing this technology into the market, they should protect that thing. So anyone, any R&D, any company's R&D, what they do first, they first file for a patent. Now even the government has to file for a patent if they want to have the exclusive right over this technology, their own technology. Now the patent filing things. In the patent filing, first of all, we need to know that there are about 30 forms in the patent field. These 30 forms have different utilization, but for any applicant, we need not to acknowledge or know about all the 30 forms. We just need to know about these 5 forms. Now these 5 forms are more than enough for anyone. And if there is any discrepancy or any timeline left or anything, then those forms come into picture. Or if you want to change anything, if you want to change the inventor things, or if you want to change the applicant or any specification thing or anything, any modifications, then those forms come into picture. Else these forms are more than enough for any applicant. Now we need to understand all these 5 forms so that we can in a better way we can draft our application and we can put forward our application to the office. Now the first form is form 1. Now this form 1 has just some details regarding the applicant, the inventor, address, and all the basic details are need to be filed in this form 1. The day when you file this form 1, from that day onwards, your technology will be registered from that day. Now, if you think that I have filed for patent application today, if you have filed on today's 4th of April. Now, if I have filed for my application form 1 on 4th of April, now on this 4th, your application will be treated as a priority date. Now, from this day, you will get the priority date. Now, the form 2. Form 2 is a form in which you have to give all the things related to your application, means all the description things. And now there are two cases. If you are a student or a researcher or anyone, and if you have not completed your invention till now, if you are working on it, and if you think that in the upcoming 4-5 months or 6-7 months, I will be able to complete my thing, and I will get to know the about my invention properly. I would get all the information. I know all the processes through which I will be going to process that thing. So in that case, you can do one thing. You just need to file form 1 and form 2 with provisional specification. Now, what does that provisional specification means? Provisional specification means just you have to give the small description about the thing that you are going to do. Means this is the earlier prior art, and I am working on this technology, and this will be my technology, and this is the way I will be going to produce. Now you just have to give the basic details. You need not to give any claims or anything in that. Now, from the day of filing this form 1, form 2, you will be given complete 1 year to complete your invention. In the in complete 1 year, you have to file this. Within 1 year, you have to file the complete specification. Means आपने अगर जो है 4th of April 2022 को अगर प्रोविजनल एप्लीकेशन फाइल करी है, देन आपको कंप्लीट स्पेसिफिकेशन फाइल करने के लिए 1 साल का टाइम दिया जाएगा. मींस 4th April 2023 से पहले आपको कंप्लीट स्पेसिफिकेशन अपनी फाइल करनी है. अगर आप फाइल नहीं करते हैं तो इन दैट केस योर एप्लीकेशन विल बी ट्रीटेड एज अबेंडेड एंड यू विल नॉट बी एबल टू process that application then. आपने अगर ये दोनों फॉर्म्स फाइल कर दी, now you have this form 3. Form 3 is just to disclose, just to tell the office about the foreign filing things. Means if you want to file your application in any other country as well, or if you have already filed that application in US, UK or any other country, in that case you will have to tell the office that in these different countries I have filed a similar application, or I am going to file the similar application. You will have to tell all the processing with the upcoming time that now my application in this country has been has been published. Now the examination has been done in this country. So all the details you have to give in this form 3. Now the 4th form is a form 5. Now the what is the importance of this form 5? Form 5 come into the picture in the case when you are filing any application in a provisional way, or if you are if you think that you actually don't know about the complete thing. Let us assume that I am a commerce student and I don't know how to manufacture this cap, but it's not necessary that if I am a mechanical engineer or any other person, then only I'll get this innovation thing, that only I will get this idea. No, idea can come into anyone's mind. It's not bound to any knowledge or any specification of any field or any specialization. So maybe I am a commerce student and I came across with this idea and I want to manufacture this thing. Now, because I am a commerce student, I don't have any idea how to manufacture this thing. I don't know what are the problems that may be linked with this things manufacturing. So what I will do, either I will go to any of my friend who may tell me about this thing, or anyone. And let us assume that any of my mechanical or any other friend told me that now this is the way of manufacturing this, we can use that different manufacturing processes of mechanical engineering, from we can use this type of plastic and we can use that. Or so after adding that person as a co-inventor in your application, we came to know about this complete thing. So now within 1 year, I have contacted, let us assume 5 people, and they now become a part of my invention. So now they are treated as a co-inventor, because nobody will help until and unless you will make them as a part of their, if you don't make them a part of your invention, until and unless nobody will help you. So for that reason, this now this gap has two inventors now. The one, me, and the second one is the friend who told me how to manufacture this thing. So for that purpose, we have this form 5. Now when you have filed this provisional application, in the form 1 you have told us that there is only one inventor, that is me. But after the completion of the thing, I came across that now there are two inventors. Now you have to tell us that who are the actual inventors after the completion of this alleged invention. And for that purpose, we have this form 5. Now in form 5, you have to declare as to inventorship. Mean declaration as to inventorship means who are the actual inventors now. Now these are the 4 forms we know. Now the last one is the form 18. So after filing all these 4 forms, your application will be published in the Indian Gazette. Means if you have filed any application with all the 4 forms, your application will be published, but it will not be examined until and unless you have filed this form 18, and you won't get any patent. Publication doesn't mean you get the patent. Publication is just like कि आपने जो है अपनी जो भी इंफॉर्मेशन थी कि मैं ये कर रहा हूँ, उसको हमने गवर्नमेंट ने आपको एक गैजेट में उसको पब्लिश कर दिया, बट उसका कोई रिलेशन नहीं है कि आपकी वो टेक्नोलॉजी नोवल है या इन्वेंटिव है या एक्चुअली उसको पेटेंट मिला है, उससे कोई उसका कोई लिंक नहीं है. You will only get the patent after your file is examined, and for that purpose you have to file this form 18. Now this, for form 18 you have 48 months, means from the date of filing of this form 1, from the date means today if I have filed this form 1 means 4th April 2022 to 4th April 2026 तक मेरे पास जो है form 18 फाइल करने का टाइम है. Why this time is given? The reason behind is that now your application is published, and after 18 months at max, your application will be published. Means from the date of filing up till the next 18 months, in between that time period, your application will be published. But after the publication, what will happen now? This your invention has come to the public notice. Means लोगों को पता चल गया, मैन्युफैक्चरिंग इंडस्ट्रीज को पता चल गया, सबको पता चल गया कि this is the new invention or alleged invention that someone has filed. Or you may self go to multiple companies or manufacturers or multiple investors that I have filed for this technology in the patent office, and if you think that this technology is useful, then you can please invest in my thing. Now agar aap commercialization is your first motive, then in that case you need to understand your invention first. Means कि आपने क्या फाइल किया है, कि आपने फाइल किया है तो उसका पर्पस क्या है, उसकी कॉमर्शियल वैल्यू क्या है। अगर आपको कॉमर्शियल वैल्यू ही नहीं मिल रही उसकी कुछ भी, देन इन दैट केस आपकी यूजलेस है आपकी टेक्नोलॉजी। सो फॉर दैट पर्पस दिस फॉर्मेटिंग कि उसकी टाइमलाइन जो है उतनी ही पढ़ाई गई है, जस्ट टू अंडरस्टैंड कि आपको एक नॉलेज, आपको एक टाइम मिल जाए जिसमें आप अपनी मार्केट स्टडी कर पाए। सो इन आपको जो 48 मंथ का टाइम पीरियड मिला है, अगर बाय चांस आपका मेन सोल पर्पस जो है वो सिर्फ आपका कॉमर्शलाइजेशन है और आपको लग रहा है कि मेरी जो इन्वेंशन है इट्स नॉट यूजफुल, इट्स नॉट practically feasible, it's not market feasible, then in that case you may not go for this examination thing and you can save your money. So for only that purpose we have this large difference in the timeline, this 4 years of time between the first form 1 date of priority to this. So these are the different 5 forms that anyone has to file for his application. Now the fees linked with the forms. Form 1, with the form 1 you have to give 1600 if you are a natural person, startup, small entity or any educational institute. Means कोई इंडिविजुअल है या एजुकेशनल इंस्टीट्यूट है या स्टार्टअप है, मींस स्टार्टअप की एक या स्मॉल एंटिटी, ये दोनों की आपको एक सर्टिफिकेट होता है जो गवर्नमेंट आपको देती है कि आपका जो है बिजनेस की जो वैल्यू है 250 करोड़ या उसके बेसिस पे आपको एक सर्टिफिकेट मिलता है गवर्नमेंट की तरफ से। आप सर्टिफिकेट के साथ जो है अपनी फाइल करते हैं कि या आई एम अ स्टार्टअप एंड इन दैट केस आपको जो है ये वाली फीस एप्लीकेबल होगी। मींस नेचुरल पर्सन, नेचुरल पर्सन, any individual or any group of individual or small startup or educational institute, like means Akal University, if they are filing for any patent, then in that case this fees will be followed. Now if you are not in this category, then if you are a company, then for those this is the fee. Now if you want to file any application, then there are 2 modes. First is if you want to file any hard copy, then you have to go to the patent office and you have to file it by yourself. Means if you want to file any application, then you have to come either to the Delhi patent office or Kolkata, Mumbai or Chennai. In these office you can file any hard copy. Or the easy mode is the online filing. If you want to file through the e mode, then you just have to log in this website and now this page will came and in this you just have to sign up, and after signing up you just have to put in your username, password and all the basic things, and you will see all the forms in that page in the and form 1, form 2 or other forms. You just have to draft your application and fill all those forms and submit it. Now there is another thing which is called expedited examination. Usually in the past years we have seen that many people have the complaint that there is such a long time a person has to face after filing any application. Means people has to wait for 4 to 5 years for getting the information about their patent. So in that case there is another way of filing that is called expedited examination. In this expedited examination thing, your application will be fast forwarded. Means it will get in a lesser time your application will get the response. So for the eligibility thing, for getting getting eligible for this expedited examination, these are the criteria. Either you need to be a startup or small entity, or any of the applicant in the application should be a female, or either you are a government organization, or you have chosen India as a ISA or IPA in the PCT. Now I will explain this fifth point in the next upcoming slides. So if you fall under these categories, you can file for the expedited examination. If not, then this thing becomes possible for anyone. Now there are multiple ways of filing the application, and these ways are ordinary, convention, and PCT. Now whatever I have told you in the past application is the ordinary way of filing, means form 1, form 2, form 3, form 5, form 18. Now this is the ordinary way of filing. Convention way of filing is almost similar to ordinary filing. The only difference is that if you have filed any application earlier to India, means if you have filed any application in UK earlier to India, means if you have filed your application today in UK and you also want to file this application in India, then in that case your application will be treated as convention application. And for that thing, you will have to file the application within a period of 12 months. Means if you have filed it today in UK, means 4th April 2022, then you have to file the application on 4th April 2023. Before this date, you have to file in India, else you will lose your priority. Now all the other forms will be similar to the ordinary application that I have already told you. Now these two modes are already I told you. Now the third is the PCT application. Now what is this PCT application? In the PCT application, basically, first of all, now PCT WIPO, World Intellectual Property Organization, has multiple countries as a part of their member, and out of these multiple countries, few countries are international search authority. Means if you file any application in this PCT, you have to choose any country out of those ISA as an examination, as a searching authority. Like there are many countries like US, UK, India is also a ISA, and China, Japan, Germany. So there are many countries. Now, if you choose India as a ISA, means as a searching authority in this application, in this PCT application, then you become eligible for the expedited examination. Now we need to first know why this different mode is brought. The thing is, in these application, you don't know actually whether I have done a proper invention, whether I have made anything patentable or not. Patentable means for getting a patentability criteria check, you will have your application will go through three different steps, and these three things are first is the novelty thing, means your application should be new, your invention should be new. Second is the inventive step. Inventive step means your application should have some new innovations, something new addition. If you are doing something in the prior art, if you are adding some new technology, if you are adding any new element, then in that case there should be something new addition to that, and this is called inventive step. And the third is the industrial applicability. Industrial applicability means industrially feasible. It should be industrially feasible. Now if you think that I have created something out of the blue and this thing is very useful, but the thing that you are creating is not industrially feasible, then in that case your application will not get the patentability. Your application will not pass the patentability criteria on that basis if your application is not industrially applicable. So in these two application modes, in these two processes of ordinary and convention, your application will get this patentability report when your application is under examination. But in the case of PCT, if you have came through this process, then in that case you will get the report first. You will get the patentability report through the ISA, any of the international search authority that you have chosen. From them you will get this patentability report. Now after getting the patentability report, now you know that your application is patentable. After getting to know that my application is patentable, I can easily go to any country and file for patent in those countries, and this report will be treated as a first thing, and it is treated as a important report, and they will follow this report if they think it as useful. And it's not necessary one has to definitely follow it. No, it's not like that. They are advised to follow it, they can follow it, but maybe they find out any other document, or they found some new document better than this PCT report, so the report may be different. So in that case, in this PCT thing, you will get the patentability report, and the chances of getting the patent is very much more. So in this process, if you are going through this process, and if you have chosen India as a PCT as a ISA, then in that case your application will become can be expeditiously examined if you have chosen India as a ISA. Now there are two different applications which may not get the patent, and these two application things are, if any application is related to atomic energy, or any application is related to defense thing, then your application will have to first we will send your application to the concerned department, means to the atomic energy department and the DRDO. And if they allow us, then only your application will be published and examined, and then only you will get the patent. If they won't allow, then your application will not be examined or published. Now the examination thing, your application go through these examination processes. Now in the examination, there is a formal examination, then the technical examination. In the formal examination, we will just check all the basic formal things, all the forms, all the fees, whether you have given the form other things in a proper way, or you have followed the timeline or not. And the second is a technical examination. In the technical examination, you will get the patentability report, whether the thing is patentable or not. After this examination, we will send you a first examination report. In the FER, we will send you some objections with your thing. Now after this first examination, you will have to send us the reply of this FER. After getting your reply, if you have we think that you have complied all the things, then you will get the grant. And if we still think that you have not complied all the things and there is still some objections, then we will call you for the hearing. And now in the hearing, we will discuss all the things, all the technical things face to face in the hearing. It can be a video conferencing thing, or maybe a physical meeting. Now if we think that everything is correct and everything is done properly, then you may get the patent, or maybe it may be refused. So this is the basic thing about the patent. Now the basic timeline, I have already told you that from provisional to complete, you have 12 months. For the request for examination, you have 48 months. Now for the FER, you have 6 months, means for the reply, means if we have you the reply today, and from today to the next 6 months, within these next 6 months you have to send us this reply. Now these are the different timelines in the basic timelines in the patent. Now the last two heading, the subheadings, pre-grant opposition or post-grant opposition. What are these? These are basically the oppositions that your application may face either before the grant or maybe after the grant. Means if anyone, if I think if you have filed for any application, any invention, and if I am any industry, and I have any company, and I think that the thing that you have filed is already been manufactured by us, or if it is our thing, then I may file this thing in pre-grant opposition against you, or maybe post-grant opposition against you. Now the second IPR is design. What is design? What is the purpose of the design? First, we need to understand that thing. Design is basically a very important thing in IPR, because before knowing any technology, before getting to know about any complex things, about anything we see, whatever, what is the first thing which we came across? The 2D 3D structure of that thing, the visuals that we the ergonomics of that thing, the looks of that thing. मीन्स हमें कैसी लग रही है वो चीज देखने में, वो फर्स्ट ऑफ ऑल हमारे कैसी, मतलब उसका लुक्स में कैसी है, फर्स्ट हमारी फेस, फर्स्ट हमारा उससे एक्नॉलेजमेंट होता है. मीन्स अगर हमारे पास बहुत सारे मोबाइल्स आते हैं, हमारे पास 10 डिफरेंट कंपनीज के मोबाइल रखे हैं, इन दैट केस फर्स्ट व्हाट वी सी कि हमारे जो डिफरेंट मोबाइल फोन्स रखे हुए हैं, इनमें से इनका लुक्स किसका है, कैसा है. आफ्टर लुक्स कम्स द टेक्नोलॉजी, वो डिपेंड करता है पर्सन टू पर्सन. सेकेंड थिंग, लेट अस अज्यूम कि आई हैव अ restriction of some amount. Means if I want to buy a car and I have 10 lakhs of rupees. Now if I want to buy a car, there are two things. Either I have chosen some particular technology, or I am looking for any technology upgraded thing, or I am looking for a technology thing. Second thing, I choose the car on the basis of design. Means कि मारुति की ये कार है, होंडा की ये कार है, होंडा की ये कार है, XYZ मल्टीपल कंपनीज है और सबके अलग अलग डिजाइन है. नाउ जितनी भी कंपनीज के जो डिजाइन हैं, वो अपने लुक्स के बेसिस पे बहुत सारे बायर्स उसी के बेसिस पे बाय करते हैं कार्स को. दैट केस जब इकोनॉमी जो है सेम हो जाए या टेक्नोलॉजी सेम हो जाए, लाइक टेक्नोलॉजी सेम हो जाए, मींस मारुति जो है, मारुति इज प्रोड्यूसिंग 2 different cars. First is Artiga, second is S-Cross. Now both the cars have the same engine. Both the cars engine part is almost similar. The difference is both cars designs, and costing is almost similar in both the cars. Now अगर मुझे Artiga लेनी है या S-Cross लेनी है, in that what I will see and I will go on the basis of the design and my utility. So design comes into picture when economics becomes equal of any two products or anything like that. So what is industrial design? Industrial design means feature, shape, configuration, pattern, ornament, composition of lines or any colors, and which can solely be judged by the eyes. Means eyes से जो भी हम देख के जो भी चीज जज करते हैं, that comes under the design registration. And for the design registration we have the time period of 10 years. Means you can register your thing for 10 years, and it can be extended up to 5 more years, and the total time it will be 15 years. Now what are the different forms that we and fees related to the design thing? In the design thing, we for any individual startup, anyone, the fees is 1,000 rupees, or for any other companies or others, this is 4,000 rupees. Application for form 1 we have to file with this design thing, and this is the basic details that you have to fill for this design registration. Now this is the specimen of the design sheet. Now look at this picture, this kettle. Now it's a teapot. Now there are something we need to understand. If you are registering for a design thing, then you won't get any registration over any mechanism or mechanical process or anything linked to that thing. Means अगर ये जो kettle है, teapot है, इसमें अगर कुछ टेक्नोलॉजी यूज हुई है या फिर इसमें कुछ भी अगर डिफरेंट सा है या फिर इसमें कुछ हीटिंग प्रोसेस अलग है या इसका मैन्युफैक्चरिंग प्रोसेस अलग है, उसके ऊपर आपको कोई भी राइट्स नहीं मिलेंगे. You will only get on the registration over the design on the basis of this shape and configuration, nothing else. जो फर्स्ट पॉइंट है मैकेनिज्म और मैकेनिकल कोई भी आपको रजिस्ट्रेशन नहीं मिलेगा. Second is you won't get any registration key if you put any mark on this thing, means any letter, if you add any letter over this thing, means if I write S on this, now it's not like that this becomes a second design thing. Now it becomes a novel thing for design. No, it's not like this. We need to understand the only thing that we becomes eligible for the design registration only when the thing has a different configuration or 2D 3D structure is different, other shape is different, only then you will get the design registration. Now the third is the trademark thing. Trademarks, we already know about trademark a little bit. Everybody knows about it, and we all have so many ideas related to कि इसका मार्क ये है, ये वाली कंपनी जैसे हमारे टी शर्ट्स हैं कि एडिडास है या नाइकी है या फिर कोई भी मल्टीपल जो भी या रीबॉक है, तो क्लोथ ब्रांड्स हैं, ये डिफरेंट जो चीज हैं उनकी जो भी लोगोज हैं, ये जो भी है मार्क्स हैं, ये सब ट्रेडमार्क के अंदर आते हैं. एंड व्हाट इट विल हेल्प एनीवन फ्रॉम रिकॉग्नाइजिंग their product. कि if I want to buy any product related to Adidas, then I can easily differentiate that product on the basis of the logo itself. So trademark help us, and it also help in distinguishing the source of the goods or services of one trader from those of the other traders. So what is a trademark? Trademark is any word, name, symbol, or device, or any combination of all of these. Now, what are the subject matters that can be registered under trademark? It can be trade names, trademarks, collective names, certification marks, taglines, slogans, shapes, or sound marks. Sound marks means now everybody knows that whenever you open any mobile, there is a sound which comes just after rebooting or just after opening your phone. Or if you open any Windows laptop or Apple laptop, there is some sound which tell us that this belongs to this company or the operating system belongs to this thing. So these are the sound marks. These are all trademarks. Now there are two different things in which we can register our trademark. There are two different terms, that TM and R. Now if your trademark is already registered, then it comes with R. If it is already been registered, and if it is under the process of registration, and if you have filed it and you have not get the trademark till now, then your logo will come with this TM thing. This TM recognize that your application houses and are recognized that this is already registered. Now we see there are so many water bottles or cold drink bottles we see come across, like after the company name like Bisleri, you will see a small R written on that, or Aquafina or any other company. Or if you go to any outlet companies, fooding outlet companies like McDonald's or Domino's or Haldiram, these are all registered trademarks. So after their name or logo, you will see the R written on that. So what is the thing about trademark registration? It will be registered for a period of infinite time period, but initially it will be registered for 10 years. Now after within 10 years, you will have to renew your trademark, and you can extend it up to infinite period of time. Now the next is the copyright. As we all are related to you all are related to the educational field. Now you must have heard this term very well. Whatever site you go through, any site, YouTube, Facebook, or any other, your Akal University's website, that all these comes under this copyright act and laws. So what are the different subject matter that you can register under copyright is any literary work, artistic work, dramatic work, musical work, sound recording work, or cinematographic films. These are the different subject matters that you can file under the copyright thing. Now it's not necessary कि आपको copyright लेना बहुत mandatory है. It's not like that. Whenever you create anything and you put that thing in any recognized public platform, like if you have created any video and if you have uploaded that video on YouTube, that on the day of on the day of that video's publication, on that day itself, that thing comes under the copyright registration. You can ask for infringement on the basis of that date itself. You can go against anyone on the basis of that YouTube platform itself. But the thing is that if you register your thing under copyright, then you have the this proper paper, authenticated paper from the office that this particular work is done by that person. Now we can see that there are few latest examples related to copyright, and we can see that recently some new things become viral. Some songs become viral, like Kacha Badam, Pakka Badam, or like Bachpan Ka Pyar. So these are what? These are the creations of some unknown, and they created those things, and they become very popular. And some music industry or some singers have copied that things, have taken the right from them, and they what they did, and they made the song of those others' creativity. Now, if that person, the badam seller, knows about this copyright thing, knows everything about this copyright act and copyright thing, then what would have had happened? That person would have asked for a better royalty out of his creation. So this difference comes into picture if we know about other things in a better way. Like इसका एक बहुत बड़ा एग्जाम्पल ये भी है कि there are so many book writers, उनको may be recognized now कि today we are writing this book, but we don't know actually कि in the upcoming days this book become very popular, or maybe in the upcoming 5 years, or maybe after any event it can become popular. Now there's some example like Chetan Bhagat. Chetan Bhagat books become very popular, Now he may not be knowing that I will become that much popular. So your creativity is not like कि आप रजिस्टर क्यों कर रहे हैं या फिर उसका बेनिफिट क्या है. उसका मे भी हो सकता है कि आज नहीं, आज से 5, 10, 15 साल बाद जो है उसका आपको प्रॉफिट एक्चुअल में मिले. और ये भी हो सकता है आपका एक दिन में ही उसकी जो पॉपुलैरिटी है वो इतनी बढ़ जाए कि आपको बिल्कुल इकोनॉमिकल सिनेरियो चेंज हो जाए. तो बहुत डिफरेंस एकदम से आ जाता है आपको उस चीज की. आपने अगर कोई भी चीज रजिस्टर कराई है और अपनी क्रिएटिविटी की आपकी इंपॉर्टेंस समझ रहे हैं तो आपको रजिस्टर करानी चाहिए. अब जो कॉपीराइट के अंदर हम these are the different terms we use to call to the different proprietors कि on the basis of their work, like literary work we call them author, music work music composer. So these are the different terms we call them. Now in copyright, this is the term of protection. For any published literary work, usually the term of protection is life of the author plus 60 years. Now for the cinematographic, it is life of the author plus 60 years. For broadcasting production, from the life of the author to the this 25 years. Performance right is for the 50 years. So this is the timeline term for protection. Now this is the form that you have to file for this copyright protection. This is form 14, and you just have file your form along with your work, and just you have to pay the fee on the different modes, and you can register for the copyright. This is the different fees for the copyright. Fees is 500, 2000, and for all the different works we have the different fees. Now the next is the SICLD design. SICL design is nothing, just a simple any electronic circuit in any electronic device. What we see, like in this mobile, we have any electronic plate with it. Now this electronic plate is a combination of different semiconductors, ICs, and we have given some particular topography, and combining these different electronic things, we get a particular output. So to protect this topographic structure, electronic circuitry thing, we have this SICLD design. We can register this combination to the government and protect this from copying. Now the last is the geographical indication. Now first we have to understand that geographical indication is a right which is not given to any individual. Means we cannot file for geographical indication. Only any community or any group of people from any particular location, they can only file for geographical indication. Geographical indication is an indication that identifies a product that have a specific geographic origin and possesses quality or reputation that are due to that origin. Means आपके particular location की कुछ जो उस geography की वजह से वो जो essence develop हो रहा है, that is geographical indication. Like we have Darjeeling tea, we have Assam tea, we have Munnar tea, we have Makrana marble, we have sarees from different location like Banarsi sari, we have Kanjivaram sari, silk. So these are the different products we have that are already being registered under GI. Now government, why government do this registration? Why government protect these things? They just want these geographical places, these people, these community to get a better recognition all across the world, and they want them, they want to get a better market value out of their commodity, their product. So for uplifting their product or their work, this geographical indication is done. So you can see there are so many examples, like there are so many edibles like this mango, apple, and lychee, saffron. So these are the all are the geographical indications that are registered, already being registered. Now, we can see this validity. This is just a summary of the what we have already seen. For the patent, we have 20 years of protection. Design, we have 10 plus 5 years of protection. For the trademark and GI, this is for indefinite period of time, but we have to renew it within 10 years. And for copyright, the life of the author plus 60 years. Who can apply? Anyone can apply for these IPR except in the case of GI. Now, what are the career opportunities in the field of IPR? We have some government jobs too in the field of IPR, like we have examiner of patent and design, examiner of trademark and GI, examiner of copyright, and in the non-government organization, we have patent agents, trademark and patent facilitation and patent litigation and other opportunities in the private sector. So if you want to get other other information, or if you want to get any dedicated course on this IPR, then you can contact this office. This is situated in Nagpur, and you can contact them and get a course on this IPR. This is all about the patent filing and patent registration and all other IPR things. I would like to show a small example of different thing, and I want to tell you some little information about copyright as well. That until and unless your copyright thing is infringed, means until and unless your someone is earning out of your thing, means आपके जब तक कोई भी commercially कोई gain नहीं कर रहा, till then you cannot ask for copyright infringement. जब आप जो है किसी की भी कोई भी copyright protected या creativity का जब तक आप उसका commercialization नहीं करते, तब तक जो है वो जो भी कॉपीराइट का इन्फ्रिंजमेंट आपके अगेंस्ट नहीं होगा। जैसे आपने देखते हैं कि शादियों में सॉन्ग बजाते हैं, हम खुद भी सॉन्ग सुनते हैं, तो ये सभी हम सब चीजें करते हैं, बट क्या है कि हमारे कोई म्यूजिकल कंपोजर या म्यूजिक कंपनी हमारे ऊपर केस नहीं करती। क्यों? बिकॉज वी आर जस्ट लिसनिंग दोज सॉन्ग, वी आर नॉट गेटिंग एनी कॉमर्शियल गेन आउट ऑफ दिस थिंग्स। बट अगर वही चीज जो है कोई रेडियो कंपनी या फिर कोई ऐप लाइक गाना या सावन या XYZ या Amazon म्यूजिक, जब वो ये पर्टिकुलर चीजों को प्ले करते हैं, इन दैट केस उनको उस चीज की रॉयल्टी पे करनी पड़ती है टू द प्रोप्राइटर। नाउ वी हैव दिस एग्जांपल, लाइक ये स्मॉल क्लिप है जो YouTube की है। YouTube पे कुछ कंटेंट ऐसा होता है, वी कैन सी वेयर, जहाँ पे जो वीडियो के नीचे ऐसे लिखा होता है कि ऑडियो इज इन दिस सेक्शन हैज बीन म्यूटेड टू अवॉइड कॉपीराइट इन्फ्रिंजमेंट। इसका क्या मतलब है? इसका मतलब ये है कि जो पर्टिकुलरली सोनी पल जो चैनल है, उन्होंने जो है ये पर्टिकुलर सेक्शन में कुछ वीडियो पे कुछ म्यूजिक चल रहा होगा या फिर रिंगटोन बज रही होगी मोबाइल की या फिर कोई सॉन्ग प्ले हो रहा होगा मे बी, तो इन दैट सेक्शन आप किसी की भी प्रॉपर्टी का, किसी की भी जो सेकेंडरी जो भी कहीं और से आप किसी और की कॉपीराइटेड जो थिंग है या क्रिएटिविटी है, अगर आपको उसको यूटिलाइज करना है और उसका कॉमर्शियली अगर आपको बेनिफिट है, तो वहां पे आपको उनसे राइट्स को बाय करना पड़ेगा या रॉयल्टी पे करने की या उनकी परमिशन लेनी पड़ेगी। अब यहाँ पे यूट्यूब, जब उन्होंने सोनी पल ने ये ब्रॉडकास्ट किया होगा, जैसे टाटा स्काई या XYZ जो मल्टीपल मोड्स है उन पे ब्रॉडकास्ट हुआ होगा, तो उसके लिए उनके पास उन्होंने राइट्स लिए होंगे उस पर्टिकुलर चीज सेक्शन पे जो भी प्ले हो रहा होगा। बट यूट्यूब पे जब वो वीडियो उन्होंने अपलोड करी, तो उस पर्टिकुलर सेक्शन में उन्होंने उस चीज के राइट्स नहीं लिए हैं, और यूट्यूब इज अ वे टू अर्न मनी। तो यूट्यूब पे कॉमर्शियलाइजेशन होता है, इस वजह से उस कॉमर्शियलाइजेशन की वजह से उस पर्टिकुलर सेक्शन में सोनी पल ने उस पर्टिकुलर पार्ट को म्यूट कर दिया, सो दैट कि जो सेकंड जो भी एक्चुअल जो क्रिएटर है उस पर्टिकुलर वर्क का, वो उनके ऊपर इन्फ्रिंजमेंट का केस नहीं करते। लाइक अगर आपकी कोई बुक्स हैं, आप राइटर हैं, बुक्स राइट करते हैं, तो आपकी बुक्स जो है अगर कोई सिर्फ पढ़ने के लिए अगर आपका यूटिलाइज कर रहा है, इन दैट केस आपके ऊपर कोई भी कॉपीराइट का केस नहीं कर सकता है, जब तक आपकी बुक्स को कोई कॉपी करके उससे कोई कंटेंट, मतलब आप बुक से कोई ऐसा नहीं करता कि वही बुक छाप के कोई और पब्लिशर सेल करने लगे और उससे जो है वो अर्निंग करने लगे, then only you can go for this copyright infringement against that. Another example, now you must maybe seeing this small picture. I have bought this water bottle recently from the market. Now there are multiple IPs that I can link with it. Except trademark or XYZ, there are two other things that I can link with this this bottle. What are the two things that I can add? The two IPs are its design registration and patent registration. What we can register in design, जो हमें जो भी दिख रहा है, because the bottle has a different configuration, its looks is different, जो 2D 3D जो इसका लुक आ रहा है वो डिफरेंट है, तो उस चीज के लिए इसको डिजाइन में रजिस्टर किया जा सकता है। दूसरी चीज कि इसको पेटेंट में कैसे रजिस्टर किया जा सकता है। नाउ एवरीवन मस्ट हैव सीन द ग्लास बॉटल। ग्लास बॉटल में जो इश्यूज होते हैं कि वो इट बिकम्स वेरी स्लिपरी, तो फॉर सॉल्विंग दैट प्रॉब्लम वी हैव दिस बॉटल, एंड टू हैंग दिस बॉटल, टू होल्ड दिस बॉटल, देयर इज अ हैंडल, दिस रबर हैंडल। तो हमारे पास ये दो नए एडिशन है टू द प्रायर आर्ट। तो this new addition to the bottle can be patent registered. So in this way we can see that there are so many things around us, there are so many problems, there are so many things about which we can think, and we can innovate new ideas. So I think I may be able to clarify a little bit about IPR and all other things. And if anybody has any question regarding this IPR and all, you can ask me.
Thank you so much, sir. It's a wonderful talk. And now I'm requesting, hope all the participants learned many things from your valuable talk. Now I'm requesting few participants. Yeah, Ajit Joshi sir, please unmute yourself and ask your question. Ajit Joshi sir, please unmute yourself. Can you please start your video as well?
Am I audible?
Yeah, can you please start your video as well for our record?
Yes, sir. I have one question.
Yes.
I have one question regarding for examination fees that you have mentioned already. So, what is the charge of, if this is the international level, as well as that India for IP?
Your question is not audible. Actually, your video got cut in between. Please, can you repeat the question? Or you may write it in the chat box.
Actually, my internet issue is there, so I have mentioned the question in the chat box.
Excuse me, sir, you are not audible. Your voice is very less.
One question. This is some
Yes,
internet issue.
now you are audible. Yes. Sure. Yes, say.
Yes. Ajit Joshi sir, please unmute and ask.
I think you were asking something related to the charges of examination.
Yes, yes.
If you want to go for a ISA application, like I have told you in the ISA PCT application. In that case, you will have to pay 2500 rupees for that report, ISA report. If you choose India as a ISA, I cannot say what is the fees in other countries, but in India, the fees for this ISA application is 2500. And about the examination fee for the patent normal cases, the examination fee is 4000 rupees.
It is for individual or for institute point of view?
For everyone,
for
for everyone except any company, the fee for the examination is 4000 rupees. Like if you are individual or group of individual, or you are a startup, or you are any educational institute, or you are any small entity company, then in all these cases the fees is 4000 rupees for the examination.
More questions. I heard about that after getting awarded the patent, then
Yes.
every year we have to charge some fees for the.
Yeah, it's a renewal
for
fees. Yes. After getting the patent, there is a very nominal fees for renewal of that patent. And if you are actually commercializing your product, this I think maybe 2-3,000. I don't know the exact value, but it's not much. It would not bother anyone. If you want to renew it, is really useful patent. It won't bother you at all.
So
But
like
there-
if the award years patent, then if we have to each year we have to deposit minimum amount, or maybe for 5 year or like 6 year, like 10 year.
No, actually, you have to pay it after within 1 year. After each year, you have to pay some amount.
Okay, sir. Thank you. Thank you very much.
Thank you, Ajit Joshi sir. Now, any other participants who have any questions, please ask. Unmute yourself and plus raise your hand, and then we will give you access to ask you the question. Any other participants? If not, sir, can you, Shalendra sir, can you please explain a little bit what is the punishment if anyone violates the copyright of other persons? Then
Actually, you
legal
can
action.
go if someone has infringed your copyright thing, you can directly go to the district court, and he will be charged for that thing if he is not ready to give you the royalty.
Thank you, sir. So any other participants or any other from my colleagues, yeah, Atul sir and
one thing I just want to add to my presentation, I have forgot to tell that while drafting your application, it's become very necessary to draft the application. This patent application drafting becomes very much important. If you have not drafted your application in the defined way that I have written in that slide, that title and then background of the art, after that drawings, explanation about the drawings and claims, abstract. If you have not drafted that application in that manner, there are more chances of getting there are more chances of not getting the patent earliest, because the way of drafting the applications becomes very important while filing for a patent. If you explain your application in a better way, if you know what is the prior art to your application, if you know what was the earlier technology on which that device was working, or what is the addition that you have done, if you know everything, it becomes very much easier for us as well as for everyone to understand that application. It becomes very much easier for you to explain us कि this is what I have done, and और जैसे मान लीजिए हमने कुछ साइट करके आपको दिया कि these are the document that discloses about your invention. Now, the more broader you becomes about application, the more broader reply you will get from us. Means if you specify your invention in a best way कि this is the specific thing कि ये particular चीज है जो मेरी invention में अलग है, ये ही मेरा characterizing feature है, तो ये हमारी फिर रिस्पॉन्सिबिलिटी हो जाएगी कि वही कैरेक्टराइजिंग फीचर जो है किसी साइटेशन में होना चाहिए. अगर वही आप एक्सप्लेन करके नहीं बताएंगे कि मेरा क्या कैरेक्टराइजिंग फीचर है, देन इट बिकम्स वेरी मच ब्रॉड. कि क्योंकि अब जैसे मान लीजिए आप सिंपल सा एग्जांपल देखिए, कोई सी चीज इनपुट का और आउटपुट का जो बीच का डिफरेंस है वो आपकी टेक्नोलॉजी होती है. मींस आप जैसे मान लीजिए आपको यहाँ से मुझे यहाँ से दिल्ली से अकाल यूनिवर्सिटी तक आना है. अब हमारे पास बहुत सारी कार्स हैं, हमारे पास टोयोटा की भी कार है, हुंडई की भी कार है, होंडा की भी कार है. सबका आउटपुट सेम है, सबका इनपुट पेट्रोल डीजल यही होगा, लेकिन सबकी टेक्नोलॉजीज अलग है. अब आउटपुट इनपुट जब सेम है तो आपको बताना पड़ेगा कि मेरी टेक्नोलॉजी में क्या डिफरेंट है और उनकी टेक्नोलॉजी में क्या डिफरेंस है. और अगर मैं ही वो मान लीजिए मैं ही होंडा कंपनी में हूँ और मुझे पेटेंट के लिए फाइल करना है, तो मेरी जो पास्ट टेक्नोलॉजी थी जो होंडा में मैं यूज कर रहा था पहले, तो मैंने जो अब नई क्रिएट करी है टेक्नोलॉजी, मैंने अब क्या एडिशन किया है. अब अगर आप वो चीज नहीं डिस्क्लोज करेंगे तो इट बिकम वेरी मच ब्रॉड की हमें भी शायद वो चीज ढूंढने में ज्यादा डिफिकल्टी हो, समझने में भी डिफिकल्टी हो कि एक्चुअल में आपकी इन्वेंशन की एसेंस क्या है.
Means we need to specify our findings and what is the difference between the already established.
Actually,
and
I am telling you the good way of drafting.
Yeah.
You can draft, you can get the patent, but the better you draft your application, the more chances of getting the patent at a lesser time.
Okay. So yeah, there is another question from Dr. Rupali Rastogi. Madam, can you please unmute yourself and ask?
Hello, sir. If my paper has been published and if I want to get a patent, can it be done?
Actually, your voice wasn't
Since
clear.
you have already published a paper and then you
Hello.
want to file a patent. Is it your question? Means is it possible or not?
I think
Yes, sir.
actually उनकी voice थोड़ी सी
Yeah, sir.
blurred आ रही
Actually,
है.
madam is
It is
asking.
my work. Sir, I work, sir, and it has been published by me only in SCI journals, and now I want to get it patent. I've seen the applications, so can I patent it?
No. We need to understand this thing that if you want to get any patent or if you want to patent your invention or any technology or anything, then you have to first get the priority date. If you have already published that thing, it means it has already came to public domain. Now your publication, your paper will be treated as a citation for your own invention. Understand? So first you have to understand if you are you want to get any patent on your technology or anything, then first do one thing, just file form 1 and form 2 with provisional application. If you have not completed your work, then there is a provision of filing the form 1 and provisional application. It's not necessary that you have already completed, then only you can do. There is a way through which you just have to give the form 1 and the form 2 with the provisional thing. Now your date will be secured. Now if you have if you have published any paper in any journal, तो आपके लिए वो citation का काम नहीं करेगा आपके against, क्योंकि वो उसके date के बाद publish हुआ होगा. Understood?
Okay, sir.
So
will it have any effect on our publication or anything?
What?
Like it is not cited, it will not be cited if you have said
Yes,
that
yes.
it will
If
not
you-
be cited. So So will its citation will not increase if after patenting I'll publish that paper?
अंडरस्टैंड वन थिंग, आई एम जस्ट टेलिंग यू कि अगर आपने जो भी एप्लीकेशन जो भी आपको फाइल करनी है, अगर आपने पहले फाइल करी पब्लिश करने से, तो आपका जो पब्लिश्ड जो अब जो पब्लिश्ड होगा उसको वो क्योंकि उस डेट के बाद हुआ है। अब आप अंडरस्टूड कीजिए क्योंकि मेन गेम है डेट्स का।
ओके सर।
डेट्स का मेन गेम है कि अगर बाय चांस आपके 5 फ्रेंड हैं, आप पांचों किसी टेक्नोलॉजी पे वर्क कर रहे हैं या आप किसी लैब में वर्क कर रहे हैं बाय चांस, अब उस लैब में बाय चांस जो है आपका कोई कलीग आके आपकी टेक्नोलॉजी आपके से बात करता है और आप उनको डिस्क्लोज करते हैं अपनी इन्वेंशन या उसके बारे में कि आई एम गोइंग टू वर्क ऑन दिस, और मे बी मैंने जो आपको एग्जांपल बताया था कि कैप मैं बना रहा हूँ और मैंने कैप डिस्क्लोज कर दिया किसी और थर्ड पर्सन से, तो अगर मैंने ये डिस्क्लोज कर दिया और उसे पहले से ही पेटेंट और इन सब चीजों की नॉलेज हुई और उसको इस चीज में जो है लगा कि या this is very important and I think this has a caliber to get a so much commercial value, तो in that case जो आपका वो हो सकता है आपसे पहले पेटेंट के लिए फाइल करते हैं। इन दैट केस आप आप जब तक प्रूफ नहीं कर पाओगे तो फिर तो आपको पेटेंट मिलेगा ही नहीं, उनको पेटेंट मिल जाएगा पर्टिकुलर पर्सन को, क्योंकि उन्होंने पहले फाइल कर दिया। सिमिलरली अगर आप कोई भी पेपर पब्लिश कर रहे हैं तो वो पेटेंट फाइलिंग के बाद कीजिए। पेटेंट फाइलिंग से आप
ओके सर
पहले करेंगे तो वो आपका ही पेपर आपके अगेंस्ट जो है साइटेशन का वर्क करेगा।
ओके सर। सर जैसे मतलब अभी मैं सिंथेसाइज करा दी हूँ, केवल एनालिसिस रिपोर्ट्स वगैरह भी नहीं है, वो होंगी, तो मैं केवल अपना आइडिया पेटेंट करा लूं और वो हो सकता है?
एक्चुअली आपकी जो आधी हेलो हाँ जी,
Are you able to hear me?
आपकी आधी इंफॉर्मेशन जो है वो आई नहीं है, बिल्कुल भी क्लियर नहीं हुई है, आपने क्या पूछना है?
मतलब ये है कि मैं जैसे अभी बच्चे से काम करवा रही हूँ, ठीक है, आइडिया है, उसको पेटेंट करा लूं, फिर क्योंकि अभी अंडर प्रोसेस है, उसकी एनालिसिस रिपोर्ट्स नहीं है सर, वो सारी एनालिसिस रिपोर्ट्स मुझे लगानी पड़ती हैं कि जैसे IR UV उसका कैरेक्टराइजेशन पूरा सब कुछ लगाना पड़ेगा सर इन रिपोर्ट्स में मुझे, कि केवल एप्लीकेशन पार्ट?
नहीं, देखिए आपका पेटेंट जो है आपका कोई ऐसा नहीं है कि आपने सही काम किया है, गलत काम किया है, या आपने ये काम किया है उसके लिए ऐसा नहीं है कि जैसे आप रिसर्च वर्क में क्या करते हैं, आप रिसर्च वर्क में ये करते हैं, आपको उसके पीछे की रिपोर्ट्स, उसके पीछे के एनालिसिस, उसके पीछे के जो भी डेटाज हैं वो सब आपको उसमें इनपुट देना पड़ता है। बट दिस इज नॉट द केस इन पेटेंट। इन पेटेंट यू आर क्रिएटिंग एनी प्रोसेस और एनी प्रोडक्ट, फर्स्ट ऑफ ऑल वी नीड टू अंडरस्टैंड दैट थिंग। अगर कोई प्रोसेस और प्रोडक्ट आप बना रहे हैं तो उसमें, और आप किस चीज के लिए बना रहे हैं, बेसिक एसेंस तो उसका कॉमर्शियलाइजेशन है, टू बी ट्रू, ठीक है। अब अगर आप कोई चीज ऐसी बना रहे हैं जिसको आपको पता है कि हाँ ये चीज मैं बना सकता हूँ या बना सकती हूँ, तो उसके लिए आपको ये नेसेसरी नहीं कि उसका कुछ पास्ट डेटा या उसमें जो आप वर्क कर रहे हैं वो आपको साइट करना है उसके साथ, या कुछ भी रिपोर्ट्स लगानी, नो इट्स नॉट नेसेसरी। आप जो कर रहे हैं, जैसा कर रहे हैं, बस आपको वो लगाना है। अब मान लीजिए आपने आप कुछ ऐसी रैंडम सी कोई थ्योरी आप हमें भेज देते हैं, कुछ आपको लगता है कि मैं इस चीज की थ्योरी मैं ये भेज देता हूँ, इस पे पेटेंट ले लेता हूँ। व्हाट इज द बेनिफिट ऑफ गेटिंग दैट थिंग पेटेंटेड? नो बेनिफिट, यू आर जस्ट वेस्टिंग योर मनी। व्हाई? बिकॉज आप जो है वो खुद से भी वो उसका यूटिलाइजेशन तो कर नहीं सकते, क्योंकि वो टेक्नोलॉजी या जो भी प्रोसेस है वो आपको खुद को नहीं पता कि वो बन सकती है, तो आप कुछ गलत देंगे तो उसमें आपका ही लॉस है। तो इसलिए, और या फिर हम भी कोई आपने कोई टेक्नोलॉजी कुछ बनाई तो हम तो बैठ के चेक नहीं कर सकते। अब जैसे कुछ बहुत ही कॉम्प्लेक्स सा किसी ने प्रोसेस बोला कि इंजन में या कार में मैं ऐसा कर दूंगा या फिर मैं ऐसा कर दूंगी, और इसमें जो है ये एडिशन से ये डिफरेंस हो जाता है। अब वो एक्चुअल में हो रहा है नहीं हो रहा है ये हमारी रिस्पॉन्सिबिलिटी नहीं है, वो तो इन्वेंटर की या एप्लीकेंट की रिस्पॉन्सिबिलिटी है कि वो आउटपुट में लेके आएगा वो चीज। तो इसलिए वो नेसेसरी नहीं है जो आप पूछ, इसकी कोई रिक्वायरमेंट नहीं है। आपको बस ये ध्यान रखना है कि जो आपने वर्क किया है वो 1 साल के अंदर कंप्लीट हो जाना चाहिए। अगर 1 साल के बाद कंप्लीट होता है, केस योर एप्लीकेशन विल बी अबेंडेंड।
ओके सर, थैंक यू सर।
थैंक यू सर। एनी अदर क्वेश्चंस?
Yeah, any other participants? If you have any questions, please unmute and ask, because we need we have only 2 to 3 minutes, because Sarah is taking almost 1.5 hours, and it is we are very much unfortunate that we could not offer a cup of coffee also because this is an offline mode. So definitely we'll invite you one day in Akal University for any offline lecture. So we'll definitely in future invite you in our campus.
Sure,
Thank you,
sure.
sir. Hope we will remain in touch.
Thank you. Thank you.
Any other participants?
Sir, I have one question.
Yeah, Atul sir.
Very nice lecture, sir. I have one query that how does one start earning from his patent? Is it like if you have filed a patent, then one have to do something so that he start earning from his patent, or it is like
Listen, first of all, we need to understand the filing process first. I have already told you the timeline in between the different forms. Like in form 1, I've told you that after filing form 1, form 2, form 3 and form 5, your application will be published. Now, if your application is published, now it becomes your property, kind of your property. It's not necessary that you will definitely get the patent, but you have already filed for that invention, for that patent registration thing. You may get the patent in the future. So after publication, you can your invention will be studied or maybe read by many of the concerned R&Ds in different companies. Like if you are manufacturing anything related to, I have told you about the cap. Now the companies related to this pen manufacturing industries like Reynolds or something, any company, they must be following the invention related to this thing.
okay.
They are all following these things. So in that case, either you or maybe they themselves, if your invention is very useful, why they want to invest on that thing? Like आपने recently देखा होगा कि जब कोरोना की वैक्सीन आपकी डेवलप हुई, कोविडशील्ड या जो भी XYZ, एंड यूके ने जो है वो कोविडशील्ड जो डेवलप करी वहाँ की जो है इंस्टीट्यूट्स ने, तो वो कोविडशील्ड जो है वो यहाँ पे सीरम इंस्टीट्यूट ने बाय करा, उसकी जो राइट्स हैं. आप सोचिए, डेवलप किसी और कंट्री ने करी और आपने जो है उसके राइट्स ले लिए. क्यों? क्योंकि आपको उसकी अर्निंग करनी है. आपका रिसर्च की इंपॉर्टेंस, आपने कितना अच्छा रिसर्च किया उस पर डिपेंड करेगा, या आपने कितना अच्छा इंपॉर्टेंट जो प्रोडक्ट है वो डेवलप किया, प्रोसेस डेवलप किया, वो उस पर डिपेंड करता है. हो सकता है आपको शायद जाना पड़े उनके पास तक. आप मल्टीपल इन्वेस्टर्स के पास जाएं. जैसे आपने रिसेंटली एक कंसेप्ट आया था इंडिया में, एक शो आया था शार्क टैंक में, भी आपको थोड़ी सी अगर देखते होंगे टीवी तो आपको पता हो, शार्क टैंक एक शो आया था. बहुत सारे इन्वेस्टर्स थे, और मतलब बहुत सारे इन्वेस्टर्स थे जो रिनाउंड इन्वेस्टर्स थे, और उसमें जो है काफी सारे जो है एप्लीकेंट्स ने पार्टिसिपेट किया, और वो एप्लीकेंट्स जो है अपनी जो भी कंपनीज जो वो रन कर रहे थे या जो भी नई टेक्नोलॉजी वो बना रहे थे उसके वो उन्होंने शेयर करी. तो ये सब तरीका है अपने ही प्रोडक्ट को या अपने ही जो भी बिजनेस को अपग्रेड करने का. दूसरा बेनिफिट ये है, बाय चांस आप मान लीजिए, जैसे मैं आपको एक छोटा सा एग्जांपल दिखाता हूं. जस्ट वेट अ मिनट. Yes. Can you see this thing on mobile? In my mobile, yes. Can you see this? This is a product that everyone buys in Holi.
Okay. Yes.
Yes. Let me play this. Yeah. Now, इसमें आप देख रहे होंगे सिंपल सा क्या है ये. This is an innovation. This is called innovation. Now, who was the maker of this product? China made this product and now selling it in India. नाउ अब आप इसको अंडरस्टूड कीजिए कि इनोवेशन क्या है। इनोवेशन है कि यहाँ पे देखिए एक ही टैप में इतने सारे जो है एक सिंपल सा पाइप के थ्रू कनेक्ट करके बैलून्स को लिंक किया और उसको लिंक करके ये एक प्रोडक्ट सिंपल सा बाय आप Amazon पे कहीं पे भी सर्च कर सकते हैं, या नॉर्मल आपको शॉप पे भी होली के टाइम पे मिलता है। अभी मैंने रिसेंटली देखा था। अब सोचिए ये जो प्रोडक्ट है, अगर इंडिया में किसी ने इस चीज के बारे में सोचा होता और उसको पास ये पेटेंट होता इस चीज का, तो हो सकता है कि वो पर्टिकुलर पर्सन ना तो वो मैन्युफैक्चर कर रहा था उस प्रोडक्ट को, ना ही वो उस प्रोडक्ट को उस कुछ भी नहीं करने की जरूरत पड़ती, बट उसके पास अगर इस ऐसी टेक्नोलॉजी के ऊपर पेटेंट होता तो दे कैन स्टॉप द मार्केटिंग ऑफ चाइना इन इंडिया। अंडरस्टूड? आप आप इंडिया में उनके एक्सपोर्ट को रोक सकते थे इस प्रोडक्ट को, क्योंकि आपने इस चीज पे इंडिया में पेटेंट ले रखा था, और आप यू कैन शो दैट थिंग कि हाँ दिस product is already been acknowledged and it is being patented by me, and I will only let you commercialize this thing when you will give me the royalty of this much rupees to me for each product. तो सोचिए आपके बिना मैन्युफैक्चर करे, आपके बिना कुछ करे, आपको उस चीज की एंडिंग मिलती जो कि आपने बनाई भी नहीं थी, सिर्फ आपने उस चीज टेक्नोलॉजी को डेवलप किया था। I think maybe now it would be clear to you.
Yes, sir. Yes. Thank you very much. Thank you very much.
Thank you.
So thank you so much. Now, if other participants, if you don't have any questions, then I'm thanking you, Shalendra sir. Once again, we are lucky that today we learned many things from you, from your lecture. I personally learned many things regarding patents and how to file it and how to examine it. And it's a completely new things. And thank you so much. We are grateful to government of India also for this initiative. And thank you especially to you. Thank you so much. We hope we will remain in touch, and definitely we will conduct such events and maybe in offline mode in future. Thank you so much. Thank you so much for your valuable lecture and time. Thank you so much. Have a nice day, sir. Thank you.
Thank you. Thank you, all of you.
Thank you, sir. Thank you so much.
Thank you.
So we now just stop this meeting. So dear participants, you will get the certificate. I will mail you to your email, registered email. Thank you so much, sir. Thank you.
Okay, thank you.